And we are here. I think we're here.
Hey, hey, everyone.
Good afternoon, or is it evening for you, JR?
It's evening. It's 7:30 East Coast time here.
It is not evening here, obviously, because we're in a different time zone. Wow. We're learning a lot tonight.
Whew.
Uh, JR and me tonight.
That should be the name of the show, JR
Yeah,
and me.
JR and me, yeah, and the bear on top of that. Not legal advice. This is not legal advice, of course, and it's obviously not financial advice. So whoever bizarre individual out there who might think it's financial advice is kind of silly. By the way, um, it's just opinion. Nobody, and again, I have to say this stupid line every time, even though I've said it for a year. This is only opinion. Don't rely upon anything we say. Do your own deal and make your own decisions because that's the way it is. And if there's any bad guys out there watching tonight, hello, bad guys. And again, to all the bad guys out there, please like and subscribe if you're going to watch. That will make you a less of a bad guy. Before I throw it over to JR, and briefly, what we're going to talk about, I'm on fire. Last week, JR was on fire. Tonight, I am just burning up.
I didn't think I was on fire, by the way.
Okay. I have like a bunch of GTII tattoos on me today. So I'm just going to be like exploding. But before we get into that, and we're going to talk about legal proceedings, so it's going to be much broader GTII. Each person, by the way, who's watching tonight will be charged $3,000, just to let you know. No, but there will be a lot of information, maybe stuff that will be interesting to people who don't necessarily get involved in this. Although little old me has worked this weekend on this nonsense, but it'll be an interesting, hopefully, for everybody out there. And if anybody has questions and JR can see them, because I can't see them out of my right eye, then we'll answer questions also. And before I throw it over to JR, if I can read my own writing, what I have just a few questions for you, JR. Hopefully you can answer some of these correctly. What pain relieving drug makes you tell falsehoods?
Pain relieving drug makes you tell falsehoods.
Yeah.
Believe?
No. Lidocaine.
Oh.
Never answer an anonymous letter.
Why not?
It's an anonymous. You don't know who to respond to, right? Right, buddy? Right, buddy? The definition of a camper, the nation's way of feeding mosquitoes.
These aren't very good, Richard.
Thank you. Consciousness, the time between naps. And last but not least, why the heck is the word abbreviation so long?
I don't know. Right. Why is the word abbreviation so long?
I don't know. If anybody knows the answer to any of those questions.
That's like a Jerry Seinfeld joke.
Okay.
Seinfeld would take.
Good. Yeah, he gave me that one. I paid him $8,000 for that one joke.
No shit.
Yeah, it was. Okay, you wanted to say something, so go for it.
Yeah. So as many of you know, and if you don't know, I'm sure you're going to figure it out by the end of this channel. There was a complaint that was brought in a Nevada court to basically take GTII away from the current board and put it into receivership. And the ruling was in favor of that. And so the court ruled, and I know Richard read it, I'm summarizing it. So the court ruled that basically the board, for lack of a better term, is incompetent. There was some intentional misdoing on behalf of the board. And so the judge looked at the totality of the circumstances and all the facts that were presented to him and said, you know what, I agree with you guys, and this company's going into receivership. So a couple comments about that. That's pretty damn big. That kind of stuff does not happen too often. And when it does happen, there's good reason for it to happen. So the fact that the ruling was in favor of taking GTII and putting it into receivership, I can't say how big of a deal that is. And so the reason I'm rehashing that is because Richard and I have been involved in this stuff since the MMTLP days. And I reached out to Richard last July because Busy Brands had reached out to me to get some questions answered on GTII. And at the time, I was knee deep in congressional stuff with MMTLP. And I asked Richard to help me. And so fast forward a year and 3 months later, and Richard has been an integral part of what has been going on with GTII and has dedicated so much time and so much energy to, making things better and improving things and changing things. And I realize GTII stock is, I don't even know what it's at, a penny right now or 2 cents. It's on the expert market, so you can't even buy it. But what Richard has done in a year and 2 months is nothing short of amazing. And so I hope everybody understands just how hard he works at what he does, how dedicated and devoted he is. Richard and I were talking multiple times a day up until maybe 2 or 3 months ago, but that's because I had some things going on. And I can tell you, not only is he a joy to work with, but he is super dedicated, and much like many of the folks that work their tail off in this community, including myself, he gives a shit. So, I just wanted to give that shout out to Richard before we got started, because I know he's super excited about what he has to talk about today. And I know he's busting his ass with filings and motions and all that kind of stuff. But I thought it was important to point that out, that had Richard not been doing what he's been doing for the last 6 to 8 months with all of this, I don't know if GTII would be where it's at. I don't know where it's going to go, but I can tell you where it's at right now is a great start. So, Richard, I want to give you a round of applause here, buddy, and really shoot you some kudos.
You said that exactly as I wrote it. It was perfect delivery.
He did not. In fact, folks, he didn't even know I was going to say that. He thought I was going to apologize for last week because apparently I got some bad comments. But I had said to Richard earlier that it's amazing what he has done, and it really is. And I do wish I could have been there with him, but I've been bogged down with some other things in my life, and I did not have the time to dedicate it. I'm actually amazed he got it done without me, folks. But you know what, he did.
Anyway,
no,
thank you.
I mean that. Richard, what you did, and I told you this earlier this week, is phenomenal. I mean, I don't think people
just keep it going. Just keep it going.
I don't think people understand how big it is and how rare an instance it is.
So, I really do appreciate it, and I thank you, and I appreciate working with you and whatever, and hopefully we can take this all the way home, right, and get a complete victory. But anyway, thank you for your kind words. Very nice. Before we talk about GTII, did you think about the pizza? I said we wanted to talk pizza. Last week we talked pastrami. So I'm going to start off pizza. So as a kid, my parents were immigrants, and we lived in LA, kind of in we actually lived in a housing project. That's where we lived. But I was a little kid, so it didn't make a difference to me. But I remember going to a pizzeria there, and it was a New York style pizzeria in LA, and it was great. I mean, I still remember it 60 years later, the garlic taste. Then what other stands out is I remember, like, when I was a teenager, we'd go to this place called La Barbara's in Westwood near UCLA. Not the greatest pizza, but it was like a cheese ball. It was like 3 inches of cheese. So kind of like a Chicago style, but not Chicago style. Now what I like, just bring you contemporary style, is there's a place called Parma that has something called a Detroit style pizza, where the pepperoni, for example, would be baked into the pizza, and that is really good. So that's my 3 takes. You?
So So I have a very fun relationship with pizza. When I was a kid, I did not come from money, and my parents we all delivered newspapers on a Tuesday night as a family to make extra money. And every Tuesday night would be pizza night. We'd order, well, Detroit pizza is also very similar to what they call Sicilian pizza, where I'm from. It's more like a deep
Okay.
dish baked thick bread
Yeah.
pizza. And that's what we would get, Sicilian pizza. And so I mean, I eat pizza constantly, but one of my most fondest memories of pizza is this was a number of years ago. My son Evan was maybe 8 or 9 years old, and we ordered pizza that night. And my wife took a napkin and she started drizzling the pizza or the grease off the pizza, so that it wasn't so much grease. And we always ordered pepperoni, extra cheese, and sausage. And so she started doing this, and my son picked his piece of pizza up and looked right at her and said, "Mom, you're wiping off all the goodness." And I almost spit my fucking food out, because here's this 9-year-old kid already recognizing that truly is the best part of the pizza, is all that grease. And so I have a tradition where Super Bowl, when we do Super Bowl parties, I hand make pizza.
Oh, cool.
So I make New York style, I make deep dish, and then my neighbor owns a pizza shop. He gave me a small Sicilian dish pizza. So I make all the dough, I shred all the cheese,
Oh,
I make
great.
all the sauce right from scratch, and they're really good. They're not
Wow.
good leftover; they're good fresh.
My
So
oldest son makes pizza
yeah, it's
at
fun.
home.
Kids love
But that's
kids.
great.
Kids go nuts.
I didn't realize it was such a personal experience for you. That's
Yeah,
great.
yeah.
That is great.
We started doing it the night before Thanksgiving, but then when we started hosting Thanksgiving, it was just too much work. So I shifted it to Super Bowl. And so now every Super Bowl, it doesn't matter if the Eagles are in or not, it doesn't matter. I make
Like,
4 or 5
yeah,
different types of pizza.
because if it mattered, you wouldn't be watching very many Super Bowls.
Somebody just made an Eagles comment here a little bit ago. So we'll
Oh,
see how the season goes. So
all
so
right. So,
that's my pizza story.
okay, before I ask you a question, I'm going to ask you about MMTLP quickly, then before we go to GTI. But I didn't want to like bury the lead. Like some guy does
Sure.
videos and he says, your time is. I remember this guy. It's the guy is you. I think he's a tech finance guy, and he likes Nvidia and those kind of companies. So what he says, and he's got a lot of followers. Probably has like 300,000 followers on YouTube. I mean, that's a lot. But the way he starts off his video is, your time is valuable, so I'm going to cut to the chase. So the chase is the minute order came down from the court. The minute order. So the minute order are the thoughts of the judge. Here's my ruling, and here are my thoughts. Now, attorney for the winning side, draft a formal order that sets forth my findings and lets me sign the order. And then, and based upon my understanding, that's in process right now. I would expect it sometime this week, it'll be filed. It goes to the other side. They can bitch and moan about the language. They could say, take this out, whatever, which they will, I'm sure. I'm sure they'll bitch and moan. And then there can be a response, and then the judge will either, alter the submitted order or change it or whatever. That's what's going to happen. So that will happen, I'm saying, over the next 2-week period of time. In the end, our council believes, the Nevada council, that they're kind of in a position where it's unlikely they would take any action that might be provocative because of the existence of the TRO, because they know it's watched, and because if they did it, it would be bad. And I don't believe necessarily that all the parties have a similar feeling about their relative risks. So those that don't feel like they have a big risk might not be willing to take provocative action. And I'll kind of get into that a little more as we go on. So those kind of things are happening. Documents will be prepared. Obviously, I'll let you know when the proposed order comes out. I will physically look at it and we'll do something and we'll talk about it.
Let's stop a second. There's a good question there. And this is a question that I think needs addressed, because,
Yes.
people don't understand. And so the question is, who is running GTII right now?
Yeah, technically, Luke Rabari would be the running GTII until the order is final. But he's aware of the order and he knows about it. I know he knows about it. But he would be theoretically the COO and the CEO because David.
Right, but let's flesh that out. Let's flesh
Sure,
that out because
sure,
that's 100% accurate. So Luke Barrio right now is still the CEO of the company and
correct.
still at the helm. But now he's got a judge's ruling that basically says this thing is going into receivership.
Yeah.
So basically, what does that mean in terms of what he can and can't do for the organization, for GTII? Can he make major decisions?
No, I think he wouldn't be able to do anything because anything would have to be, anything could be stopped and it would be, you could
It'd be
undo it.
embarrassing.
Yeah, well, I'm embarrassing, but it could be undo. You might be liable for sanctions. It just wouldn't be something that it would be like a desperate move. For him to do something like that, I think wouldn't make any sense.
Right.
Now, if someone else happened to be in the position of CEO and COO, and they thought they were up Schitt's Creek, they might do that. But I don't think Rabari thinks that I don't think, by the way, between you and I, in the grand scheme of things, I think this is a shit company, the way it's been run. Judge in Nevada agrees.
Right. Well, we talked about that last week.
Yeah.
We talked about
kind of is what it is. But, in the relative, putting who's in the blame pie, I don't think Luke Rabari is the main guy in the blame pie. I don't think he's completely devoid.
Well, he only came in April. He only came in April.
Yeah, either May or April. It actually started December 1. He was supposed to complete the succession plan. I'm looking, I'm just kind of now just talking off the cuff here. But I look at all this stuff. He came in to do the succession plan. And then I look, so this is December of 2023. And then I look, I think I pulled it. There's like a PR in July and those PRs are like a page long. And at the end, there's like a warning, danger, 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 stay away. And before that, there's like a comment from David Reichman because he's still, I think he would have been still CEO at the time. And, back in December 1, it says that Rabari's being brought in to take care of the succession plan. And in this PR, it says Rabari is now going to complete the succession plan. He was there almost a year. What has been going on? If he was brought in to take care of the succession plan, and now he's, according to Reichman, what he says, he's got to take care of the succession plan, then I don't know what he's done. That kind of also relates to that, we talked about this, that comment about what Rabari was being brought in for specifically. And, again, seems like he has an excellent background, honestly. You looked at him, I think it was University of Chicago. Right. I was impressed. Right. I was impressed with his background, but it's said in part that one of the primary obligations, and the whole companies, think about this. So GTII is a company that takes other companies in. And to do that, it's got to be straight and kosher and operational. It can't bring in other companies if it's not compliant. And as a matter of fact, that's what it says. It says we deliver kind of what we do. Wish I had it in front of me. One of the things we do is we deliver an umbrella of benefits, and one of those is a fully compliant, fully SEC compliant company. That says it on their website today, by the way, just between you and I. But I think they forgot to file something. I mean, maybe I'm incorrect, but I think what happened was they forgot to file like a 10Q. Maybe you can correct me if I'm wrong. I think they forgot to file a 10Q. And because of that, because they were non-compliant, they got delisted to the expert market. Am I incorrect?
That was my understanding. They
failed to
filed correctly with the SEC, and that's why they got delisted to the exchange.
Yeah, so it's interesting that they would say to the contrary. And I brought this up before. It's interesting that they don't have enough.
Well, you and I had talked about this.
Yeah.
I want to say back in early January or February, we were having a conversation about it because
we know what's going on, but not everybody does. So if somebody goes and looks, they can get inaccurate information. And we talked about it. They've watched the videos, right? They said they did, right? They sued me based upon the videos. So we know they are. So it's odd. It's odd that they kind of just disregarded that and they continue to assert direct falsehoods. I literally part of what I'm doing this weekend is, so now I'm shifting a little bit. So we started, and we'll get back to it. We started talking about the Nevada action. So that's the action. I'm a plaintiff in the Nevada action, along with 250 or so other plaintiffs. And we're kind of doing it on behalf of the entire group. But luckily enough, I'm also a defendant. I got sued by these guys in California. So I'm a defendant. So I get to participate with them. It's such a fun experience. So now, after the ruling in Nevada, I kind of feel they have a difficult case because, I was just for example, I was looking, let's use an example. They claim, I don't even know if I said this, by the way, but they claim, and I'm just going to pick, they claim 20 things in their First Amendment complaint against me. So this is not the Nevada action. This is the defamation action in California against me, but it involves GTII, and a lot of what happens in Nevada is duplicative of what happens or claimed here. So, for example, one of the claims that they say I said this. I don't remember saying this, but maybe I did. They claim on May 14th. Now, May 14th is an interesting date because that would be after that 10K came out. Do you remember that 10K that said they lost like $90 million? They cash, something happened. I don't know. It didn't look very pretty. Let's just say that.
Right.
So that's after that. So apparently, I said that GTI management looted the blank out of this company. Now, that's what apparently that's what I said. Now, of course,
that sounds like something I would have said, not you.
I know. It might have been. Maybe it was you. I don't know. But now, if you recall, in June, they had to return 36 million shares that were inadvertently and erroneously issued, if you recall that. And at the hearing in Nevada, when discussing that same 36 million shares, the attorney for GTII represented to the court that the directors were, in essence, prepaying themselves in stock for a future deal that might close, even though obviously there was no revenue and no income. But that's what they were doing. Now, that's not allowed, just between you and I. That's some people might call that looting. Some people might call it.
In Texas, they call it stealing.
Yeah. But, in defamation law, you don't have to be exactly correct. In other words, one, you have to say a false of something. The way defamation works, you make a false statement. It's intent is important because it depends on who that person is. It's got to cause harm, and it's got to be a statement of fact, and it's got to be false. What is false? If it isn't exactly 100% correct, that's not false. It just has to be basically the story. So in my view, what I just told you constitutes that, but that's not where we start, right? If you recall, I just got to do at least once tonight. I got to read from my favorite author. My favorite author is Judge Williams in Nevada. And just because it's just a fun paragraph, I find, and it puts things in kind of perspective, I just want to remind everybody what he said. And now this is not final, but this is, again, this is his view of the case after having it briefed by multiple briefs and having a 1-hour oral argument in his courtroom. And what he said is, plaintiffs will likely prevail on their claims against Global Tech Industries, Inc., GTII, current management, defendants David Reichman, Kathy M. Griffin, Frank Benintendo. That's not the same Frank, by the way. Everybody.
Poor Frank.
Yeah, I know. People think it's the other Frank. It's not the other Frank. Donald Gilbert, collectively management. Specifically, management, 1, grossly mismanaged the company by A, failing to file required disclosures, B, causing the company to be delinquent with the OTC Markets Group and Securities Exchange Commission, and C, violating securities laws and regulations. 2, grossly mismanaged the company by A, filing materially false, misleading, and incomplete disclosures, and B, intentionally omitting material information from its disclosures. 3, grossly mismanaged the company by A, personally enriching themselves at the expense of GTII and its stockholders. I'm going to stop right there. That line, you might consider that looting. So I'm going to repeat that line, and I'm going to ask you, JR, would you consider that another way of saying looting? That's the question. So what the judge said, personally enriching themselves at the expense of GTII and its stockholders.
Yes.
So
I would agree with that.
You would agree that somebody looking at that sentence might conclude that management at GTII may have looted stockholders.
Right. I would agree.
Okay.
Well,
Okay.
there's a couple of key words that you're reading here that I think people need to understand. The use of the word grossly and the use of the word intentional, those all have specific legal meanings. And when judges use those, or people use those in contracts, or you see those in agreements, those are legal words that have specific meaning. And when you have gross misconduct or intentional misconduct, I mean, I don't know how else to say it. These guys are fucked. That's the bottom line.
Yeah, just between you and I, and again, not everyone sees orders or courts language. This is, again, this is really severe. This is not like I practice, close to 40 years. Seen a lot of rulings. Obviously, they go both ways. Usually, judges kind of try to a little
candy coat things.
Candy coated, nice. This judge was pissed.
Yeah,
he really was. I mean, that's my read. Not only is my read. Go ahead.
I want to get to a question here because it's the second time I've seen it. And Vince Felice says, how long of a time frame how long of a time frame till we able to start trading it again? How long I'm assuming asking how long it is till they get around to deals.
Yeah. So theoretically you could do a deal today. You could still do, and you know why I say that? Because I heard it discussed.
Right.
So I can't really get in. I can't really get into details about whatever. It doesn't really involve me per se, but I know there was discussions and concerns again, because not everybody involved with GTI thinks they're in the same position. So some people might think they have big exposure, and some people may think they don't have big exposure.
Let's flesh it out based on the question that we talked about, 10 minutes ago. So in theory, Luke Rabari is still the CEO, acting head of the company. He can do things with the company. The problem he has is everything he does is going to be put under a microscope by the court.
Yeah.
Because say, for example, he goes to cut a deal, we learn of the deal, Richard's going to go right to court. The minute a deal is announced, anyone that knows this decision has the right to court.
I would say I'll take it one step farther, and I can't guarantee it, but based upon what I heard, he doesn't believe, I think he could do a deal.
So in theory, though, a deal could be made, but
Yes.
the judge is going to be involved in that deal. Okay.
Yes.
Now, if plaintiff's attorney and the shareholders agree that it's a good deal, and they go to the judge and say, Judge, we believe this is a good deal, the judge is likely going to say, okay, I will defer to plaintiffs in this matter. But if plaintiffs go in and say, Judge, we don't want this deal, we want receivership appointed first, the judge would have to take that under consideration.
Yeah.
Okay. So that's the first part of the question. Second part of the question about when you will be able to trade, I don't think we know the answer to that.
Yeah, the way I can tell you how it's going to go. The way it's going to go is once I think I described how we get to the order that appoints, hopefully appoints a receiver. At some point in time, a receiver will be appointed. Part of the acts of the receiver will try as fast as possible to get the stock to be able to trade again. So, and I spoke to counsel in Nevada about that specifically. So that's definitely, because I asked that specific question. So it's definitely in the cards. I don't know how long it will take, but everybody's going to be motivated to move as fast as possible because they know that everybody is kind of stuck in that position. So we don't know, but I know it's going to be coming forward. I wish it was faster. Wish all this was faster.
Right.
Okay.
Yeah.
Sorry, go ahead.
No, I'm just going to say the answer to that question is kind of unknown at this point.
Yeah. So I hadn't finished. I was at the order and we talked about the looting. By the way, the first statement that they claim that's defamatory, that's not in quotes. I don't even know if it's really said. Because again, they list 20 statements, 3 with quotes. So I don't know what that is, honestly. Is that like, we think, he thinks? What is that? I mean, it's confusing. But one of the non-quoted ones, it says GTII management diluted, stole, and/or misappropriated money from GTII. I mean, we know they diluted. I mean, there are 10 cases they diluted.
Right.
So why would you say that? And in federal court, this is kind of like taking it a little bit of a different turn. In federal court, they bought the action against me in federal court. So in federal court, when you sign a pleading, so a pleading would be like a complaint. So to remind you the sequence of events here, so I filed a complaint April 8th, June 27th, the Nevada complaint was filed, dismissed mine, joined that action along with a bunch of other people. Like July 2nd, so sometime after that Nevada complaint was filed, they sued me here. Before they sued me, but with my complaint still pending, they sent me a retraction letter. So they sent me a letter that actually was better than their complaint, but still inadequate.
Right.
That said basically retract, and I responded. And what they did is they emailed it to me, and it had my office address. And instead of serving it at my office on a Sunday morning at 6:30 a.m., they served it to me at my house, which I thought was highly uncool. I called them out on it. They apologized, but I thought it was BS, and I thought it was an attempt to intimidate and harass me. I really did. After that, they filed their action, even though there was a lawsuit pending in another matter, which is relevant. So in federal court, where they filed the action, and I don't know if there's proper jurisdiction there also, by the way. Jurisdiction means the power of the court to have the ability to rule on a matter involving certain parties. And so there's a question about jurisdiction in federal court because there's an issue about whether all the defendants are in different locations than all the plaintiffs. I'm the defendant. I'm in California. One of the plaintiffs, David Reichman, apparently represented to numerous people that he resided at the Beverly Hills Hotel. And if you recall, the Mechanic and the Masseuse, nobody can forget that show, but the mechanic was on that Bentley. So that was the thought process that he was actually domiciled in California. The other side took the position that he's domiciled in New York. So, that's where it goes. But they filed it and they asserted the truth of what they said. Now, all this they said was before that hearing in Nevada. So in essence, whatever is asserted here, the judge in Nevada says you're full of shit. That's basically what he's saying, even though obviously he didn't see what they said.
Right.
So if in fact something is stated as true, but it's not, then there's something in federal court called Rule 11, and you can file a motion to get sanctions. The sanctions can be attorney's fees, and I have somebody who's doing a little work on the side for me, who will have. So I have some bill, but my time is unfortunately not compensatable. But the Rule 11 gives the court the ability to impose sanctions other than just reimbursement of fees, because the idea of Rule 11 is to deter these type of BS filings, to get this nonsense out of court. So I'm currently preparing a Rule 11 motion. It'll be filed probably Tuesday. I told the other side it's coming. I mean, Friday I sent Friday I learned that, or my impression. Let me say my impression. My impression is that the management of GTII and the attorneys for GTII, at least the current attorneys for GTII, may not be precisely on the same page. There may be some falling out. Now that happens typically. I was going to talk about this too. That happens typically with attorneys. So if you have a client and they hire you to do something and it turns out bad, a client generally doesn't like the attorney. It may not have anything to do with the attorney, but it just kind of it's the obvious target. So I would say so far that Nevada ruling, which I haven't finished reading yet, if I was like GTII and I looked at that ruling, I would not be pleased. And I may have a thought about my attorney. Can I find somebody better? I don't know. That's what occurred to me. And that's what occurs to most clients. So that's how I'm sure it's happening with GTII. And they're probably paying a S load of legal fees. So just imagine this. They're paying an S load of legal fees, and then the judge, just so we could finish out this to make fun. So I'm the current CEO of GTII. The mail comes, I see the bill from the attorneys. It's big. I then go back, because it's on my desk. I have a copy of the order, that minute order that the judge meant. As I'm looking at that invoice, I go back to the order and it says, personally enriching themselves at the expense of GTI and its stockholders, converting company assets. Remember when we talked about the looting part? I guess converting assets, some people might construe that as looting, wouldn't you say? Maybe worse, by the way.
Sounds like looting to me.
Yeah, converting assets, that's intentional misconduct. That could subject you to punitive damages. That's bad. That's bad conduct. And issuing shares to benefit themselves, family members, friends, affiliates, and other related parties. Again, I think some people might think that might be dilution or looting or whatever. I can't say dilution. How many times can I say dilution? Dilution. Some people might say that. And, again, there's never been an explanation, if you recall, in By the way, just so you know, the reason why I'm doing this tonight is because they let me do this. I've told them, I basically said, dismiss the action. Why? I mean, silly. If we go back in time, I've had a long discussion with GTII. My intention was not for anybody to end up in jail. It really wasn't. My intention was not to anybody end up in trouble. And I repeatedly told them that if they kind of didn't take action that I was saying, it just was going to go, it just was going to get bad. It wasn't like I knew it specifically. It wasn't that I had control over that.
Hey, hold on. As you're saying this, all of these conversations are coming back to me. I remember having these conversations back in winter and spring.
Yeah. I mean, I'm telling them, I try to be like, I was pretty direct. I didn't want anything bad. I really did. I did not. I just wanted that. Honestly, we started this off. I get a bunch of people complaining. So I suspect, and there's no revenue. There's nothing going on. So I suspect there's something afoot. I asked them to tell me, explain what's going on. Then we get the nonsense about the timely 10K. If you remember that, lied about that 10K, wasn't timely filed, whatever. By that time, I knew we were deep. I mean, being a lawyer, you're a lawyer, right? You've been involved where there's been inappropriate conduct, right? At some point in time, it's just like anybody in anybody's business. If you have a business and you do it long enough and things repeat themselves, you don't have to know precisely the details, but you kind of know something's afoot.
Well, you were in communication with these guys, and the old adage that words matter. I mean, you sensed it very early on. I'm again, as I'm listening to you talk, I'm kind of remembering having these conversations with you, and you'd call and say, "Hey, this is what I'm thinking," and we'd bang it out, and you'd go and do it. And so, again, which is why I gave you kudos to begin with. You really have been knee deep in this since the beginning of the year. And I think the other thing that people don't realize is the current, the previous CEO and the remainder of the managers here had every opportunity to start doing things, had every opportunity to start making things right. They were not blindsided by this at all. I mean, they knew this was coming, and they chose to ignore and continue to do business as usual as they saw fit, and hence why they're now, getting their asses reamed out by a judge. So let's take a break though, because there's a good question in here, and then I thought of another question as you were talking, and I don't want to lose these questions because we said we were going to focus on this.
Sure.
Let me just find it again. Hold on. Can you speak, and it's from Richard Odin, can you speak on the matter of who is possibly going to take over receivership? So why don't you walk us through that process?
I think
the judge has now ruled it's going into receivership. So now what are procedural steps that happen?
Yeah, so the attorney,
once the order signed.
Yeah. So the order can, I haven't seen the order. The order could in itself have section for appointment of the receiver, or there could be a separate order. But in terms of the receiver, there would be, a receiver has been reflected already, and we know one thing for sure, based upon the order of the court, that management of GTII can't be the receiver because the court specifically disqualified management, basically because there was and again, I'm not a Nevada lawyer, but there's a section in Nevada that says basically if you've breached your fiduciary duty or whatever, you can't be, you don't get the benefit of the doubt, and you're not going to be a receiver. That's my language. That's not really the language of the statute, but the judge cited that. So it won't be current management. For example, in the opposition to the receivership, GTII's counsel, the bad guys, they proposed, so they objected, opposed, whatever. But if the court does grant a receivership, they should put Luke Rabari in as receiver. And I didn't really think that made a lot of sense anyway, but the judge seems to have put that to bed anyway. But I think the attorney was working with a gentleman by the name of Paul Strickland. Strickland, I think. I don't know him personally. I haven't worked with him. I think, based upon my conversation last week, that he has worked with him and there's been no issues, as far as I know. But that's who will be proposed. If the court accepts him, great. If not, there'll be somebody else proposed that will be as receiver. But at some point in time, a physical person will take over the day-to-day management and whatever, and it'll be in the proposed order, the duties and powers of the of this receiver will be outlined specifically in the order. He can open a bank account. He could go to McDonald's and buy lunch. Be literally a list of things he can do, and he can only do what the list provides. He's got to report to the court. Got to literally report to the court what's going on on a regular basis. And when his duties and responsibilities are completed, he leaves, and that's it. That's how kind of the process works. How long that will take, I don't know. It'll take as long as it's needed to do what we need, if that can be accomplished. There are no guarantees of anything. Obviously, GTII is in a very strained state, so anything's possible about the finances. We don't know how that's going to go. But I do feel pretty comfortable that if we had to intervene, it was for the shareholders. It was not going to be pretty. That's my.
It was headed in the wrong direction.
Yeah. So that's the answer to that question. There's a designated person now. If the court's satisfied, he will be the one selected. If not, there'll be somebody else chosen. It should not be anyone of current management.
And so the other question that I saw pop up twice was, well, what does this mean in terms of some type of criminal charges against these guys?
Well, I don't know, because we don't obviously we're just talking civil stuff, and I don't know what went on. But you and I have talked about this a lot. I don't, the judge was pretty brutal. So, but I don't know if that amounts to criminal misconduct. I don't. Although he said there's violations of securities laws and things like that. Can fraud be criminal? Yeah, fraud can be criminal, but it's tough. So
it's certainly enough to raise eyebrows.
Yeah. And again, the point is Alpine. Yeah, this is kind of like if I were in the shoes of management. And again, I don't think they understand a lot of this stuff. This is just my opinion. If I were in the shoes of management, what my concern would be, listen, Alpine's been a huge deal. So the SEC knows about Alpine. They do. Even if they weren't looking at GTII, even if that wasn't their target, just by proximity, they're going to know about this. Right. I know that at least I was told that there were whistleblower complaints filed against GTII. So I think the SEC knows. And, I don't know what went on, but, somebody could propose that the reason why somebody may not want to do a deal, may not want to expose themselves to a full and complete audit is because they don't want that to be exposed. And, we know that even though we don't know who chose the auditor, Borgers, that scam auditor who was kicked out by the SEC, was their auditor. And we know at the time that they were hired and that the prior auditor elected not to re-engage, whatever that means. That coincided at a time where David Reichman was the CEO, CFO, chief accounting officer, had been a tax expert, had been an executive at American Express. And I would think the chief, and maybe I'm incorrect, by the way, but do you think the CEO, CFO, and chief accounting officer would have any interaction with an auditor?
Well, considering they only have 4 employees, you're damn right they would.
Actually, 2 employees, just
2.
2.
2? Somebody's
Yeah,
got
I
to be
think,
talking to them.
yeah, I think, that's a tough one. I think, that's a tough one. I think that somebody in that position wouldn't know or shouldn't have known, really. And what I was going to say is, before I go back to the order and the Rule 11, so, I made a bunch of comments, right? But those comments were made before Borgers was kicked out by the SEC, before the 36 million shares were canceled, before the court's order in Nevada, before the delisting, before the non-compliance in filings. So when I was talking, and I had enough to talk about, but there was plenty of stuff that occurred afterwards that I think, any reasonable person would conclude, getting back to my case, that the defamation action was BS.
Well, it's not only BS, but you weren't really saying anything that hasn't been proven untrue.
Yeah, and that's like, so this is unfortunately the law. So at this point in time, I have to work on it procedurally. So I really can't talk about truth. So I can talk about a bunch of other stuff that I will and am, but I can't get into truth until later. I hope I don't have to get the truth, because I don't have to get the truth, then that means the case is over. And the case should be over anyway. But with all that information, but with all that information that came afterwards, it kind of confirmed specifically everything that we believed and more. That order of the court was by far more than I could have anticipated. So we get back to this Rule 11 motion. So I basically told these guys on Friday, I said, dismiss this bullshit action against me. 1. 2, to Mr. Rabari, you shouldn't be spending another dime on the defense of those defendants in Nevada. They, listen, per the order of the court, they engage in intentional misconduct. There's no reason to pay a penny towards the defense. 3, I told Mr. Rabari, through counsel, same point. You heard, listen, if you didn't know what was going on before the order, you do now. And if that's the case, why haven't you sued prior management, Mr. Rabari? What's the issue? If the judge says basically the way I read it, the judge says, besides gross mismanagement, that management ripped them off. If that's said, the converted company assets, nothing else, misappropriation, stealing or taking company assets.
I'd make the argument that he has a fiduciary duty to do so.
I think he has a fiduciary duty as to all, not to spend any money on BS cases like the one against me, not to spend fees on behalf of those who committed intentional misconduct. I mean, not to, and to pursue relief. Again, if he would go out, I don't know how much, if any, dollar amount is missing. I don't know what the damage figure is, if any. How much should GTI really be valued today? But there appears to be things that went on that there may be an opportunity to recoup assets or money. And I don't know the wealth of any of the people, other than that somebody told me, I don't know if this is true, by the way. I have no idea if it's true. I'm going to throw it out. Why not throw it out, right? Somebody told me they knew David Reichman, and they estimated, and again, I have no idea if this is true, because I don't know his net worth. So I don't know how much stock he had in GTII or other companies. I don't know how much he sold. I don't know what kind of real estate he owns. I've heard, but I don't know what kind of real estate he owns. But some guy told me that he was worth between 50 and 100 million bucks. So if in fact that is what he's worth, And if in fact, what the judge found is correct, then Mr. Rabari should seriously consider, potential relief.
So, Richard, a thought just popped into my head. It's a good thought, so I think it deserves some conversation. So, when you and I both took corporate law, and the purpose behind incorporating or limited liability company or partnerships is to protect the individuals. They call it the corporate veil. And so when we're talking about what the judge said, there's a legal theory called piercing the corporate veil. And if you pierce the corporate veil, that means the people that are running the company now have personal liability. What are your thoughts on now individual lawsuits targeted at Reichman and board members under the theory of piercing the corporate veil because of such misconduct that the judge outlined in the memo?
Yeah, to the extent they're not obligated personally, and I don't know, at this point, I think he said they personally basically looted, back to this. I think in essence he said they personally looted the company, they converted company assets. That's acting for their personal benefit over for the benefit of the company, and that would be like a set of facts by which you would try to pierce the corporate veil. Some of the other things are like it's undercapitalized. There's a whole series of events. The way you conduct your business, do you adhere to formalities? By the way, and it's funny. I had a conversation with Jack Fattel. That was the attorney who came in, who said they were going to file the 10K timely back March 31st. During one of our conversations, and by the way, I have an email, of course, where I say this back to him. But during one of our conversations, he says, this company he didn't say it exactly like this, but this is what he stated. GTII did not follow corporate formalities. In other words, some of the stuff they did, because small companies are sometimes sloppy in their adherence to corporate formalities. By the way,
right.
is the way he would have phrased it. He was referring to GTII. It was part of his whatever he was doing. I don't even know what he was doing at GTI. I don't know if he's still at GTII, but whatever he was doing, he at least had examined some of the structure of GTII. And if you recall, again, April 9th, Rabari in that PR, it said there's deficiencies in operations and the setup of GTII.
Right.
So it's interesting that it was disclosed, the deficiencies, because deficiencies in corporate structure are another basis for piercing the corporate veil. So if you don't hear the corporate formalities, you kind of use the company as your personal piggy bank. By the way, I sent him an email, I think, where I said you're using the company as a personal piggy bank. But in essence, when you're converting company assets and you're giving shares to family members and friendlies, and I heard, by the way, and I don't know, by the way, if it happened here, but the foundations, there was an allegation about giving shares to foundations, and I don't really know what happened, but I was reading about another company and how they did it. And what they would do is the principal would donate a bunch of shares of some BS penny stock that was overvalued. They would then get some kind of capital gain tax credit, the person. Eventually, they would do some short cover down the road. But it was really, the way it was disclosed, it was really a tax play for the party donating the shares.
Right.
I don't know who donated the shares to. In this case, there were several, if I recall, there were
several donations
to foundations, right? And that there's an issue, right, about the legitimacy. I don't know. Is that legitimate, not legitimate? Is it the same setup? Is it the same I just mentioned? Was it done solely for a tax benefit? I don't know, by the way, also, if it's done solely as a tax. So if you do that and your intent is not to inflate the asset, to inflate the value, so you're presenting an inflated value in a tax transaction, which you're getting a tax benefit in? I mean, I don't know tax law. Something about that sounds like that could be problematic.
Well, yeah, it's not. I mean, for lack of a better term, it's not kosher.
No,
It's just,
no, it's not. It's not.
well, the reason I brought it up is because it popped into my head, and there were a couple of comments that you need this, you need that. I mean, piercing the corporate veil is a state law theory, so it's different on a state by state basis. But
Yeah,
in this regard, you would have to bring it in Nevada because that's where the company is incorporated. But it's not any one thing as opposed to the totality of the circumstances. So all
yeah,
the facts of the case are looked at to determine whether or not, my verbiage might be a little off here, whether or not the board was using the company as their alter ego. That's my
yeah.
recollection.
Yeah,
Then
something like
you
that.
look at a variety of things under that to determine, well, yes, it was their alter ego, and we're going to hold them personally liable because it really
Yeah,
wasn't.
and that's not something you're going to get to till down the
Sure.
road.
Down the
whatever.
road. But again, we're having conversations.
Right. So yeah, so that's interesting. It's an interesting situation.
Well, I think the judge's comments opened the door to developing that argument.
Yes, yes.
Again,
Yeah, yeah, again, I was there, I or at least I viewed the hearing, and when it was like an hour and 10 minutes, and it was that last 10 minutes, it was that 36 million canceled shares for prepayment. When and he didn't even go to this point. Prepayment, he was gone already. He thought that was BS. I mean, he didn't say it, but he said it. He said it. So it's okay to pay yourself ahead of the close of a transaction. Is that what you're saying? Like that? And then when he said the inadvertent and erroneous, and that was that they had issued those shares inadvertently and erroneously, although they didn't tell you what happened to the other 35 or 30 million shares that weren't canceled. He was done. That was it. That was also the end of the hearing. And that's what's reflected in the language. So getting back to what I was going to say, and I'll try to keep this brief because this probably is so boring by this point in time. So I filed a rule. I'm filing a so this is to my opponent, who I've told, I said, dismiss the action, and then we can talk after you dismiss the action. Until the action is dismissed with prejudice means it's gone forever. We're not going to have a discussion. That's kind of where I left it with them. Pretty clear. I left it with both current counsel and moving on. I'll leave it at that. So I'm filing a Rule 11 motion. The way a Rule 11 motion works is the other side has an ability to avoid the liability on the motion if they dismiss the action. They have 21 days to do that. So on probably Tuesday or Wednesday, I'll serve them with a copy of this Rule 11 motion. There's also a motion per 28 USC 1967, which basically is a bullshit action statute. Says if the attorney files a bunch of bullshit actions, then you can get sanctions against them for filing the bullshit actions. So the difference between that and the Rule 11 is Rule 11 they can get out of if they dismiss the First Amendment complaint. 28 1967 they can't. So that kind of continues on. Maybe a mistake. Again, I gave them the opportunity, and if they decide they want to dismiss, give me a call after you dismiss. Then we can speak. So I have to serve them with this. I have to give them 21 days. After 21 days, then I file it. So let's say this motion will be heard, let's say 60 days out. After I file this, before September 10th, I will file a motion to dismiss. Separate and apart from this, the motion to dismiss is basically their actions bullshit. That's the legal theory. On top of that, there are certain, besides truth, because truth and that, you mentioned that. So in a motion to dismiss, I can't raise arguments that would require an exhibit to be attached to my motion. So if I had to attach a letter, for example, I can't do that. It's got to be based on the complaint as it is and whatever attachments are the complaint. However, I can request judicial notice. In other words, I could ask the court to take notice of certain filings that have been done, including, like, you know, for example, the minute order of the court in Nevada, the lawsuit, the receiver application, and the lawsuit that I filed. And the reason why, and I filed mine April 8th, and I gave them notice, they knew about it, whatever. The reason why that's interesting and important, and it'll be litigated, we'll see how it goes, is because in California, there's something called a litigation privilege. And it's an absolute privilege. So anything discussed in any way related to a litigation involving something you're involved in, doesn't have to be in court, doesn't have to be specifically about the case, but related to the case, can even be, by the way, prior to the case. It could be like in contemplation of filing litigation. It could even start by, if you send a demand letter to someone, that could be the start of the litigation privilege. And, you know, just to bring it to everybody's attention, on February 6th of 2024, I sent out a demand letter to these jokers, basically saying, you know, come clean, tell me what's going on. If I don't hear back from you by February 26th, I'm going to take legal action. My opinion, they're going to have a tough time with the litigation privilege, excluding everything else. And that's absolute. So if the court, and by the way, the standard is if there's any doubt as to applying the litigation privilege, you apply it. So it's a pretty difficult burden to overcome, because courts don't want people to get sued for things they say during lawsuits. Because otherwise, if we're in a lawsuit and I call you some name, you're going to sue me. And then every lawsuit's going to generate 10 lawsuits. How does that benefit anybody? It doesn't. So the courts have set up a procedure that if there's certain, even presuming that what they claim is defamation, even if it was illegal, even if what I said was illegal, even if it was unethical, even if it was disgusting, and it was none of that, by the way, it was absolutely true and accurate.
The use of your foul language is disgusting, Richard.
Yeah. But even if it was absolutely false, untrue, improper, intended to cause embarrassment, it's absolutely privileged. And
all right, we got some questions that are coming up here that are pretty good, Richard.
Okay,
I don't mean to cut you off.
Go for it.
Hold on, let me go back. I just want to make sure we're addressing the people.
Sure, that's good.
Can't seem to move my mouse. Okay, there we are. All right. Okay. Oh, Junk Savvy. After receiver has completed their work, where does the company go from here, from there?
Yeah, then there will be
Then
yeah. So at some point, there'll be a process. Either the existing CEO would be probably voted out by the board of directors and a new CEO would be voted in. That would probably be the conclusion. And the receiver would kind of manage that process.
So I don't know, but I'm going to ask a question because that's how I was thinking about it. So wouldn't the receiver come in, kind of get things in order? All right. So right now we know there's some SEC filings that are outstanding, probably some auditing that needs to be done. So once the receiver would come in, they would get all that in order. And then don't you think they'd go to the largest shareholders and say, okay, you know, do you guys have a slate of board of directors? How do we want this to work in terms of putting a board together so that shareholders can vote on these positions?
Yeah, I have not.
That's how I assumed it would work.
I have not gotten to that point. I just want, my point was get a receiver installed.
Sure.
And then I would from there.
Could they have?
Well, the way it goes is that action in, it's possible. Yes, it could happen that way. But, also the way the action was structured in Nevada, it's a majority of the shareholders, not the shares. So theoretically, let's say a proposal comes forward and our attorney in Nevada says, this is what they have. Do you guys want to do it or not? There would be a vote. And if, if there's 250 and 126 people say yes, and 124 say no, it's approved. So it's not, the way it's structured up front does not necessarily benefit the largest shareholders.
Well, again, I'm just envisioning things in my head that makes sense to me. I don't know. I honestly don't know how it would go, but I think the short answer is at some point the receiver is going to have to deal with that issue, because the receiver is not in perpetuity. The receiver's there is just to get things in order, straighten things up, clean up whatever messes need to be cleaned up.
Correct.
And then at some point, the receiver is going to have to turn it over to a legitimate board.
Correct.
How that board comes about is yet to be determined.
Yeah, I assume ultimately the court, as long as the receivership's ongoing, the court's going to have to sign off on everything. So
exactly.
If it's the receiver appointing a board and the board reports, then appoints a CEO, all that, as long as the receiver is still engaged, will be through the court. Once the receiver is not engaged, then you have an existing board and CEO, whatever, and now you're operating as a normal entity. So that's kind of how it would fly. Yep. How long that will take, it really depends again on, we don't know, really. We're now like in the 9th month of 2024, no financials, right? We have no idea what happened in 2024 to this point in time. We know 22, 22, and 23, pretty much a disaster. 24, I doubt if there's any income. But we don't really know, the bottom line is we don't know what's going on. And, it's not unreasonable to suspect that there's a reason we don't know what's going on. And that when you we will. Oh yeah, definitely we will. Because part of this is, and what the GTII crowd says is that they are engaged in an audit. That's fine. Fortune, I think, is the name of the auditor that started sometime about May or June. It might take, based upon, I'm using NextBridge as a model for how long it will take to do the audit. NextBridge did an audit of 1 year, 2022. They had Borgers. They got rid of him in February. The audit, I think, was completed in June. Something like that. I think it took them June, maybe July. In my head, when I heard it, it was like 4 months. I don't remember the exact time frame, but when I heard it, it was like 4 months to do 1 year. So here there's 2 years they have to do, 2022 and 2023. I don't know how long that's going to take, but I wouldn't be surprised if there's magic stuff that comes out of it that we didn't know about. Maybe it'll be good.
You're going to find a rabbit in the hat.
Listen, maybe it'll be good. Maybe like Borgers didn't credit like $100 million in cash, and it's there, but they just didn't put it there.
And we forgot about the $100 million.
Anybody can miss it. Yeah.
Look, and please don't take Richard's word. I would be blown away if that happened.
Yes. Yeah. I would say generally, you would expect that if a company like Borgers, because they were accused, and they're not in business anymore, but they were accused of making up work papers and doing an absolute sham job. Generally, you would expect that when you re-examine those things, that things would not improve. They maybe stay the same, or they might get worse. So I
think you're going to get a lot worse.
Yeah, I don't know. It could be, maybe we'll be surprised. Maybe we'll be surprised. But I wouldn't expect a windfall of, even though I was joking, the $100 million, I'm not expecting a windfall. But we need to see it, what it is. Because,
well, we just don't know. That's the bottom.
We don't know. We don't know.
Point taken. We don't know.
Yeah. Yeah. I don't know if Rabari knows.
Probably doesn't.
But, Rabari has gotten 8 million shares already. And he's in line to get another 16 million
What's that at? 8 million times what? 0.03? What's
400.
the
Well, I give him 5 cents. That's $400,000. He's probably also accredited. So theoretically, he might now. He's got a. Usually, there's a hold on insiders. So if he gets shares, there's usually a restriction on how fast you can get rid of those shares. But for the sake of discussion, if those shares were worth 5 cents and he has 8 million, that's $400,000. He gets a bonus of 10 million shares if that stock price goes to $2. If he's getting 20, just think about this and why somebody might be pushing back against this. Rabari's contract, he could possibly get 34 million shares. If he hits that $2 mark, that's like 70 million bucks.
Well, he's not going to get the opportunity to hit that mark. He is not.
Yeah, I don't know. I don't know because I haven't. Although I indicated, part of what I indicated in Nevada, they can't because he's not a party. He wasn't like one of the people sued, but he sued me. So he gave me the opportunity to now, if he continues on, I said this, by the way, and it didn't make a lot of sense to me, but they did it. Why would you expose your shares to me? In other words, in Nevada, there's nothing they could do about it because you're not a party. You just made yourself a party here. So even if you're not in California, I can go after your shares as a shareholder. Well, we'll see what happens. We'll give it a shot. Again, it didn't make a lot of sense to me. Didn't sound like it was really thought out very well. One, because again, I think it's a bullshit claim, but two, because it kind of opens the door. It also opens the door to David. He sued me, which is hysterical, by the way. You think about this. He sued me for defamation, David Reichman. But he opened the door. I can go after him also. Now, I prefer not to waste my time and effort, whatever, but it allows me to. So getting back to the motion to dismiss, that's what I'm working on. That'll be filed before the 10th. And it'll assert a bunch of defenses. It'll be asked for a dismissal with prejudice. It'll ask that the case be over. And I think it's pretty frivolous. And once I file it, I'll go into detail about what I specifically said, but I don't want to say it quite yet. The Rule 11 is coming out this week, so I didn't mind it. The other thing I'm filing, so this is the third document I'm filing, and just think about this. Whatever I'm saying, that means the other side has to review, and these are going to be lengthy documents with lots of exhibits. Because emails, and I got
because you're semi-retired and this is all you do.
That's all I do. 24 hours a day. But they have to take all these documents, review them, file oppositions, review the replies, go to court. It's probably going to be pretty costly, I would guess. And they don't have very much upside here. I mean, the upside is they could prevail on these motions. That's the upside. But on the Rule 11 motion, they'll get no attorney's fees. I mean, certainly it's a good faith. I have a good faith belief in what I'm asserting in terms of the Rule 11 violations. I know that they're violating Rule 11, but I feel comfortable that I have a good faith belief. The motion to dismiss, no fees go either way. So they have to do theirs, whatever on my end. I'm also filing something called an anti-SLAPP motion. So a SLAPP action is an action designed to shut somebody up, to shut down their First Amendment rights. And in California, there's a statute that says if you publicly if you take a public position for the benefit of a public issue or an interest of public interest, like this, it's protected speech. And once you establish that, and it's a pretty easy, I just established it, by the way. Once you establish that, then the burden of proof shifts to the other side to establish that they would succeed on the merits. So it's not a procedural case. They now have to show why they'd win. Not an easy hurdle to, because theoretically they'd have to expose a lot of things that they may not want to expose, because they have to establish it with admissible evidence. The benefit, so that's how it goes. So it's separate than the motion to dismiss. It's a third document. There's no whereas in the Rule 11 motion, I said I had to wait like 21 days before I could file it. No such prohibition here. They could obviously dismiss. They might be liable for legal fees and costs. And it's reportable. There's some California bureau that actually monitors these things. And the Rule 11 sanctions also is reportable. So if you're an attorney, and we had discussion, it's funny that it works out. You and I had a discussion about GTII a long time ago. We discussed a legal action that they brought. Do you remember that?
Vaguely.
I think there was an attorney. I think it was Wes Christian. I think he filed a lawsuit. I don't remember what it wasn't about what we're talking about here. It was a spoofing. It was spoofing lawsuit. Yeah. And eventually it was settled. And I think he admitted later, but I kind of knew because somebody told me, but he admitted on one of those calls on X that Rule 11 played a role in the end of that case. So in other words, somebody may have raised the issue of Rule 11, that they were going to pursue Rule 11 sanctions. And because someone was concerned about that occurring, that may have contributed to the end of that case. Okay. So for most attorneys, when they hear about Rule 11, if they're sensible, they get concerned. And again, this is I go back to it. This is a BS case. This is nonsensical BS. So that will be filed at or about the same time as a motion to dismiss, but before September 10th, because that's when my response date is. And I don't know if before that, I'm expecting, I can't imagine. I've been surprised in a lot of ways about this matter. I did not understand from the start why management did not capitulate. Just didn't get it. Didn't get it. And I wouldn't understand now why they wouldn't tomorrow dismiss the case against me.
Well, I think it's not that they didn't get it. I think it's that they thought you were going to go away or lose steam. I would be hard pressed to think that they wouldn't dismiss or withdraw on their own. I mean, they just don't have the facts, especially in light of the order that the judge is ultimately going to sign. It is a rule. My own personal opinion is it is a Rule 11 violation at this point. Richard, and I'm going to go back to what I said at the beginning. You have become a thorn in their side, and now the thorn got jammed in harder with the judge's ruling. So I'm proud to have worked with you, man. You kept up, you kept hitting away, and all those late nights and goofy morning calls we had, it paid off.
Yeah, he calls me like at 5 o'clock in the morning. He forgets that we sleep past 5 o'clock on the West Coast, unlike the East Coast, where obviously people are awake, by the way, at that time.
I forget you're in California at 7:30 in the morning.
The benefit is I think.
Whoa! You called me at 1 a.m. the one day. So
I did. I know. Okay. All right. The benefit is where I live, and it happened. So it's today. It's Saturday, Sunday. What day are we? Sunday. Today's Sunday. It was Friday night. I got to see another one of the SpaceX launches.
Nice.
Yeah. That's so awesome. I've seen about 10, and it was late. It was like 2 o'clock in the morning, but it's really cool to see. And at some point in time, It takes like 2 minutes. It takes off at Vandenberg, which is a couple hundred miles down the coast. 2 minutes. All of a sudden, I see a sparkler in the sky. What it literally looks like. A sparkler coming across the sky. It's really, really cool. I don't know what he has. I mean, somebody's asking. All I'm saying is what somebody mentioned. It could have 45 cents. I have no idea. All I know is though they did sell a lot of stock. If you recall, they regularly sold stock. And they sold stock even after I said don't sell stock. Probably a bad move now.
Well, I don't know what he has either other than a foot up his ass right now from the judge.
I don't know. I mean, I literally said stop. And
Right.
they continued. And it wasn't just him. It was all of them. And I know like they were confused. Do you remember like Kathy Griffin? She sent me a email. Now, Kathy Griffin is not on my team. She's on the other team. And she said, and it was kind of funny at the time, and of course I alerted her of that so she wouldn't do it again. But she said that Hoffman, basically she was pissed at Hoffman, and she was wondering if Hoffman could say those things about Reichman. And that's again before we knew any of this stuff. So this is really early. And she's sending me, again, when you wonder, how does a company get to the position it is? There's a lot of mismanagement. That includes like one of the board of directors sending a email about their legal strategy to the other side. That's probably not advisable. And by the way, that's not the only time it has occurred.
Yeah, and let me just I always like to inject personal experiences. It out here in the real world where you work for a company that's got 3,000, 4,000 employees, when you make those kind of mistakes, a mistake like Kathy Griffin made at that point, your ass is fired. It's that simple. Your ass is fired. You're done. You're not working here anymore. So, it was funny as hell at the time. I mean, we've had a couple of good chuckles like that.
And we had another one, right? We had another one more recently, right?
Yes.
That it just again, when you see kind of multiple continual acts just of kind of incompetence. That's all it is. How could you do that? I presume they're not doing it intentionally. Maybe somebody trying to be like a whistleblower and they're trying to do it in a very subtle way. And this is how they're doing it. Is that possible? I guess. But listen, if I were somebody at GTII today, just based on our conversation right now, this conversation, I'd be awfully concerned about what people at management are telling the other side, either intentionally or unintentionally. Because again, it just seems like they don't know what they're doing. Just another example of them not knowing what they're doing. So we've spent like 90 minutes ripping these guys. 90 minutes. Are there any other questions that you want that you see?
I haven't seen any. I mean, we've addressed all the big ones that I thought were pretty relevant and that we should educate people on.
Okay, so kind of to summarize. So this week I expect to see the proposed order that will include and be related to the receiver. I then will expect a bunch of opposition, objections, whatever, and then maybe a reply, and then eventually the court will issue an order hopefully appointing the receiver that's selected, if not some other receiver. He's already indicated, that that's what he wants to accomplish. I don't know what other legal maneuvers may occur. My impression is that the GTII is not happy with their current lawyers, but we don't know what will occur. Once the orders come out, the objections, whatever, I'll keep you apprised of what's going on. I literally just like I did, I read the order. I didn't even finish the order because JR wouldn't let me. But even because it had more, the judge wasn't even done. He just got started. But there'll be like a process, and we'll do that. Then there'll be a process of appointing the order, appointing the receiver. And then obviously once the receiver is appointed, I will try to kind of make sure that because this is my goal, I'll try to make sure that our interests are protected at all points to the extent I can. Right. And, whatever, whatever people think's important, I'm happy to consider it. I'm considered to be the point person, so I'm happy to get whatever suggestions are. But ultimately, I'm not the decision maker. I don't make the decision.
You're not the.
Yeah, I know. So so receiver appointed. I'm filing a Rule 11 motion. I'll file a motion to dismiss. I'll file an anti-SLAPP motion. We will see if the actions are dismissed. I wouldn't be surprised if there are some negotiations ongoing and some attempts that are ongoing in the background. Would not be surprised at all. Now, whether that results in anything, I don't know, because I don't know. Ultimately, when parties discuss settlement, you don't know what they have in mind, what they think's reasonable or not. We don't know. But I'm sure there will be there's a potential opportunity always for resolution. Because if you were on GTI's side, right, and you kind of thought my risk is pretty big here, then maybe you'd want to see if you cut it off at the pass. I'm not one, just like I said, I told them I would have no discussions with them until they dismissed my action. I will not engage in any settlement negotiations that I think sells shareholders down the river. I don't know what that's going to be, but I'm not inclined that way, nor does it make a monetary difference to me either way, honestly. I'm obviously a shareholder, but nobody's paying me. I'm not expecting payment, and my interests are shareholders. So we'll take it wherever that goes, however that goes. JR is barely staying awake, by the way. I tried. My goal was to put him to sleep. I was
I was up at 5 o'clock this morning.
Nearly, probably calling me. It was 2 o'clock at my time.
I think I texted you.
Okay, all right. I think you probably did. What kind of settlement? What kind of settlement? A settlement might be, what would a settlement be? A settlement might be the return of shares. So you might take, there might have been 380 million shares. Let's say you can get a bunch of shares back and you can reduce it substantially. So anti-dilution is certainly good for shareholders. It does provide positive pressure on the stock. It's more important, of course, once the stock is able to be traded again, if that occurs. Because once it's able to be traded again, the anti-dilution really comes into play. You might have people contribute money. So if you found out that somebody took money or took stock or took property, you might have them contribute money, or you might have them return stock, or you might have them provide real property, or you might have them provide other securities or bonds or whatever. So those are all types of settlements you could do. There's obviously other types of settlements, but in terms of monetary, those are kind of the things that come off the top of my head. Sure. Yeah, I agree. The Eagles suck. Even JR is going to agree to that. Yes. What can you do? What can you do? Any other questions that you can think of?
No, you wanted to focus on GTII, and I think we did that tonight. So I think it was a good conversation. We answered a lot of questions, and I think we've made some clarifications for folks, and we'll see what the week holds.
Yeah, we don't know how it's going to turn out because the judge's order is not final, but the judge's language is pretty strong. And when I was going through my Rule 11 motion, there's a lot of stuff. When you go through it fact by fact, there's a lot. There's a lot. It's really a bad.
Well, you got really a bad picture.
It's a bad picture.
Good meat.
Yeah. I mean, usually you don't have the opportunity. Most cases, like I told you, one case I had, I ended up, the judge said, deny. That was his entire ruling. A lot of times that's the ruling. Not, in this case, I thought again, because we didn't get an immediate ruling, that was probably a good sign because the judge could have just said denied. But we don't know yet because we're not at the end. We'll have to see when we get to the end. But obviously, we will keep you apprised as we go. And obviously, if I'll keep you apprised of the lawsuit against me, and I'll keep you apprised if anybody visits me at 6:30 in the morning again. Anyway, anybody who sees this at some future point, or now or later, or whatever, if you have questions, please put them out there. We'll try to address them and give you a coherent response. No guarantee about that, by the way, the coherent response.
I'll give a coherent response.
Yeah, you will. You'll, at least one of us will. But we'll try to give you an update. Well, obviously, you know, as we've done, I think we've done a good job about this. We'll keep you updated in real time when we know stuff. Sometimes when there's a gap, you know, in time, like there was a gap between when the lawsuit was filed in Nevada and the order of the court. That was just kind of the court calendar. So sometimes it takes longer. It's not because we're not disclosing something. It's just sometimes maybe there's not information to disclose. But we will disclose whatever is real, and if there's any major events besides this that impact you know, an outcome or the situation, will obviously come to you right away. Anything else you want to add?
Nope.
Wow, I spoke a lot.
You did.
I know.
You had a lot to say.
I know.
That's because I swelled your head at the beginning of the show.
Yeah, you did. You did. You absolutely did. You want to finish by like give me more praise? Like 15 minutes of more praise?
No, I'm done, man.
All right. Anyway, I appreciate everybody who was here tonight, everybody who asked questions. And again,
yes,
if you have
good questions.
Yeah, it's appreciated, actually. I appreciate everybody thinking about it. And if you guys have future questions, feel free to comment, you know, when this is posted. Appreciate it. We'll see you again, I'm sure, next week with hopefully non-GTII talk or less GTII talk. Although we don't know, maybe it'll be another impactful week. But anyway, everybody was here. Thank you very much. Be well, take care, and we'll talk to you again soon. Take care.
Bye-bye, everybody.
Oh, I got